Okay, yeah, here we are again with more agritourism. So I want to do a quick recap of what we talked about last time. So some of you are going to recognize some of the content that we'll discuss today. Around this time last year, I presented a webinar on landowner immunity statutes, which of course includes agritourism liability statutes. And in some ways, today's webinar is a part 2 of that presentation. For those of you who did not catch that webinar, I've included on this slide a link to the recording and some related materials. You can access these materials from the PowerPoint slides or from a link to that event, which was posted in the chat. And then some of these materials will be available on the event page for this webinar too. In that webinar, what we covered was a lot of different topics, including the following. We talked about liability and the duty of care owed to trespassers, licensees, invitees. For the lawyers on the call, a little bit of a reminder of law school there. And then we also talked about the types of torts that one might see in a civil liability lawsuit, negligence, intentional, and strict liability torts. I also briefly mentioned the types of protections available to landowners, which includes liability insurance, entity formation, waiver, state immunity legislation. We talked about those in depth. But our focus was, of course, on state immunity or liability legislation. In that webinar, we put the spotlight on Pennsylvania, and we talked about the Pennsylvania's Agritourism Activity Protection Act, Pennsylvania's Equine Activity Immunity Act, Pennsylvania's Recreational Use of Land and Water Act, and Pennsylvania's Right to Farm Act. With today's webinar, we're going to both broaden our focus in some ways and in some other ways narrow our focus. We're going to broaden our focus in that we'll still discuss Pennsylvania law, but we're going to spend some time talking about other state laws and looking at the United States as a whole. We'll do an overview of what type of state laws have passed relating to agritourism. So it's just an overview of those laws. And then in narrowing our focus, we're going to do a deep dive into the specific language that's used by states in designing their own agritourism statutes. We'll mostly talk about liability laws, but I'm also going to talk about some other standalone agritourism laws as well. I'm going to ask and then hopefully answer the following questions. So what laws affect agritourism operations? What type of state legislation relates to agritourism? What are the major similarities between state liability statutes? And then what are some significant differences between state liability statutes? By the end of this, I hope to give everyone a better idea of what they need to do to acquire agritourism liability protection in their state. And also, hopefully show you some fun facts and explain some of my interest in the topic. All right. For those of you who are new to this topic, and as a reminder to anyone who doesn't remember this from last year ago, here's a reminder. There is currently no official federal definition of agritourism. Since we're going to spend some time looking at and comparing different state definitions, I'm not going to attempt to provide a general definition here. On this slide, I've just included a list of some things that are commonly seen as agritourism activities. There are things on this slide that may seem to be very clearly an agritourism activity on its face, but that activity might not meet some state definitions. Conversely, there are some things on this list that aren't obvious agritourism activities, but might be included in the state definition. So to me, obvious things are, hay rides and pumpkin patches, corn mazes, anything fall related, really. You pick operations, that's pretty much agritourism. Petting zoos where you get to pet the goat or, hold a chicken, that seems like agritourism. But, things like, barn weddings, that's always a contentious one. Goat yoga, I love talking about goat yoga because it's one of those things that makes me laugh, but I wonder, how is that agritourism? But, it is for a lot of states. So this is just an example of just some of the things that we think about when we're thinking about what is an agritourism activity, what pops into our mind. So agritourism operators, they have to know a whole bunch of different laws. There's a lot of laws that affect them. We've got the tax laws, federal regulations, local zoning and permitting laws. And then you also have to figure out if you have to purchase insurance or if that's just an option for you. But it kind of depends on the activity. Now, The first few bullet points on this slide, they're difficult, if not completely impossible, for me to address in a way that would be relevant to the specifics of everyone's operation. So in other words, I'm just going to go ahead and skip taxes entirely. I'm going to briefly mention regulations and insurance, and then I will instead focus on my main point here, the main point of this presentation. So state statutes and state agritourism liability laws. So what are the regulatory considerations for an agritourism operation? Regulations are going to be based on the specific type of activity. For example, if you are opening an on-farm restaurant, you'll need to follow food safety laws or liquor laws, or maybe you're offering a petting zoo or some kind of animal interaction, and you need to learn about animal welfare laws. There are a lot of different programs out there that are available to help farmers navigate these rules properly, but those programs can be hard to find. The first step is to look around online or attend local events hosted by farm support organizations. You can also check out the resources document that we shared on the event page of this webinar. On that document, there are links to guides that help new agritourism operators get started. And I wanted to throw in this slide just focusing on zoning, because when it comes to regulations, this is one of the biggest hurdles that I hear about from new operators. So when it comes to zoning, you're talking about things like allowed traffic, parking areas, hours of operation, noise and lighting, structures, things like that. And I'm sure that this doesn't need to be said, but make sure if you're working with a new operator, or if you are a new operator, make sure that the operator speaks to the local zoning office. And when they do that, they get everything in writing. I've heard some horror stories of people calling or sending me emails where the farmer is certain that they were approved for XYZ aspect of their farm or of their operation. And then later they were told, oh, well, you can't do XYZ. Just get everything in writing. It's the right call. And, there's sometimes nuance to this. You might ask, oh, is it okay if I do, hay rides? And they say, oh, sure, you can do hay rides. And then they find out like, oh, well, you can't do hay rides with that tractor. Like there can be some nuance to it. So get it in writing, make sure that you're clear about exactly what you intend to do with your agritourism operation, and get it in writing. One quick note on this issue before I move on. Is some of the agritourism cases that I'll highlight near the end, they are focused around local zoning laws. I read through a handful of cases to prepare for this presentation, and the general idea that I've gotten from those cases is that a farmer wants, you have this. So let's say the farmer wants to start an agritourism operation, and then someone else doesn't like it. That's usually the crux of the issue. The common argument in those cases is that the activity isn't agricultural, and therefore it's not permitted on land that's zoned for agricultural use. Again, I'll talk about a case or two later, but I just wanted to bring this up right off the bat to sort of set the scene when we're talking about zoning. So while lawsuits based on zoning are not uncommon, when I'm talking about liability, agritourism liability, these are the types of liability lawsuits that I think of. These are the ones that pop into my head. So negligence, strict liability, intentional torts. When we start talking about agritourism liability or immunity statutes, these are the type of lawsuits that those statutes usually aim to prevent. However, in most cases, we're talking about negligence, so that top one there. For agritourism, these are often civil actions brought by an agritourism participant who was injured while they were on the farm. And before we move on, I want to give a quick example of what a negligence lawsuit might look like on a farm. So this is just something that I've seen versions of this in different cases. So let's say that you have, a corn maze and goats, and there's a small field that people have to cross, and maybe there's a path, but a lot of people don't use the path. So let's say that one of your attendees at the operation walks across this field, but they trip on the uneven ground and then they twist or break their ankle. If the agritourism operator has no liability protection, they might be on the hook for that injury. That's probably going to be a negligence lawsuit saying that, they weren't told, or there weren't signs, they didn't know that they shouldn't cross the field. I will say that, if you're in an operation and you don't have insurance, it's pretty risky. Having insurance would help pay for that injury, so that'd be wise to do. But yeah, if the operator is able to take advantage of a state liability statute, they might be able to avoid that lawsuit entirely. Now, for any non-lawyers on the call who might want to know more about negligence or torts in general, where some of this stuff just, you're not really sure if you fully grasp what we're talking about here, we have a lot of resources on this topic that I'd be happy to share. Feel free to email me. It's jks251@psu.edu. That goes for any other questions too. You're welcome to add questions to the Q&A, but if there's something that'd be easier to explain over email, feel free to send me a message. And I'll include my email at the end if it's not already in the chat, and it's also going to be on a couple of slides here. So definitely feel free to ask about that, because I think this is something really important for all farmers and agricultural operators to know. So if you are a new agritourism operator or someone who is in a position to advise an agritourism operator, these are your key liability protection objectives. So liability insurance, entity formation, notice of risk and waivers, and state liability legislation. A couple of things I want to point out about this list. First, some operators mistakenly believe that since they already have farm insurance, because you get a farm and you have to get insurance, so they already have farm insurance, they believe that their agritourism activities are also going to be covered under that insurance. That could be true, but often that is not the case. That person needs to check their insurance. They need to call. They need to make sure that whatever thing that they're doing is going to be covered, especially if they're, well, actually in any case, but especially if they're doing something weird like a pumpkin cannon or something like that. I talk about pumpkin cannons a lot. There's a place nearby here up in Clymer, New York, where they have a pumpkin cannon. It is the coolest thing. It's one of my favorite agritourism activities, but it's weirdly enough, not a single statute mentions pumpkin cannon as a protected activity. So, I do wonder, how do they cover themselves? But that's neither here nor there. Anyways, as far as entity formation goes, make sure that the entity is the type that offers liability protection, like an LLC or some kind of corporation. This probably goes without saying, but a sole proprietorship does not automatically come with liability protections. And then next, we have waivers, which are usually a good option if it's something that's going to work with your setup. Sometimes waivers can be difficult to coordinate, but providing notice of risk might be easier to manage. Maybe it's something that you can put on your website or post on a flyer, things like that. Last but certainly not least, we have our state liability legislation. Please note that these laws are also sometimes called immunity laws, or liability protection statutes. I'm going to generally refer to them as liability laws, but if I say immunity laws, I mean the same thing. So while we're looking at this slide, before anyone says, I think this slide is missing some states, let me clarify. This list only shows states that have absolutely no agritourism related statute whatsoever. These states don't have a legislated definition for agritourism or anything. Couple caveats. One is Connecticut. So technically, Connecticut mentions agricultural tourism in a statute, but that statute is about what types of signs are permitted to be posted near the highway. So I'm like, technically, I guess Connecticut doesn't fall under this category, but that statute has, it's just like a passing reference, and it's a limited impact. So after some debate, I did include it on the no statute list. And then I also included California because California has no formal definition for agritourism. However, they do have rules on cottage food operations, and those mention agricultural homestays. Homestays, I mean, some states, include them in their definition. So it's like, that's agritourism, but they don't specifically mention agritourism. In any case, in California's law, the language in that statute allows lodging and meals to be part of the agricultural homestay activity. So California, Connecticut kind of have something, but for the most part, they don't really have any agritourism related statutes. Now, so for the purpose of this presentation, these 8 states and the District of Columbia, they do not interest me at all. And so we will not be talking about them because they don't have any statutes in agritourism. So goodbye to these states. Now, On this slide, I have states that have agritourism laws, but no application to liability. As a whole, these states have created state definitions for agritourism, but pretty much nothing else. And then for those of you who are watching from your phone, here are the 7 states. It's Arizona, Delaware, Hawaii, Illinois, Maryland, New Hampshire, and New Jersey. I probably should have read the slide, the ones on the other slide too, but I'm not too worried about it. If anyone needs, again, if you have any special requests, just put them in the chat and I'll do my best to read things from the slides, especially slides that have tiny writing. And again, so for these state statutes or these states, they do not address agritourism liability. I want to make that clear. They provide no immunity to agritourism operators through an agritourism statute. There might be other liability protections available in those states to agritourism operators, but none that meet my criteria that I was judging them by. So it's not agritourism liability protection specifically, or anything that's very clearly meant to protect agritourism activities. So these are our non-liability statutes, and we'll talk about them a little bit, but not as much as the liability ones. And on this slide, I've listed all of the states that have a liability statute. For those of you who've been working the math, you already know there are 35 states on this slide. I'm not going to read all of them, but we will go over a handful of these states as we compare and contrast different elements within their statutes. Okay, so at this point, we're going to talk about the major similarities between state liability statutes. And to do that, we're going to start with the general architecture of agritourism legislation. And that includes a definition, usually requirements for signage. We'll talk about the exception to that. And then a sentence or two, or maybe a paragraph on liability and what that means. So most state statutes have this basic language in their definition section. They first describe what constitutes an agritourism activity. And, here on the slide I have, this is an activity that allows members of the general public to participate in farming-related activities at an agricultural operation, including but not limited to. And then sometimes states will provide specific examples of especially things that are important to that state and that locality. And then they also provide a definition of inherent risks. So inherent risks, that's usually defined as dangers relating to animal behavior or ordinary dangers relating to agricultural structures or equipment. Most statutes also add in language providing protection to operators where the negligent actions of one participant causes injury to another. So if someone hurts another person because that person wasn't paying attention or didn't follow the rules, you're still protected from the person who was ultimately injured in that scenario. Yeah, and then the key language here under inherent risks, I just want to highlight this again, is dangers or hazards that are integral to an agritourism activity. A lot of the cases, a lot of the things that we see when people are using these statutes, that's often the focus. Is the activity, especially for these weird activities, is it integral to what's happening on the farm? In agricultural activity. I think I have agritourism activity, but I probably should have phrased that as agricultural activity. So like in the case of my pumpkin cannon example, let's say that it's a farm and they grow pumpkins and, you go and you pick your pumpkins. I'm not sure how you would argue that, the pumpkin cannon is integral. I think if I were arguing, I would say, people, it gets them to pick up a pumpkin, they get to hold it in their hands. It's a marketing scheme, right? You get to, put the pumpkin in a cannon and shoot it at the hill and you try to hit the target. It's amazing. And that's maybe a way that you could argue that it's related to agriculture because, you're trying to get people to buy your pumpkins. I don't know. Obviously, I am not the attorney for that farm, and thank goodness. But that's going to be the kind of argument that you'll hear. How is this activity that you're doing, especially if it's a weird one, how is this activity related to agriculture? Okay, so almost all states with liability protections also have signage requirements. This section requires the agritourism professional to post and maintain signs at clearly visible or conspicuous locations at the site of the agritourism activity. Some states give you the exact language that needs to be on the sign. The statute might say how big the letters need to be. It might say how big the sign needs to be. It might even say the color of the writing or the font. They can be pretty specific. So before you just go make a sign and post it somewhere, double check your statute, see what it needs to look like and what needs to be on there. And just check your sources. And I just wanted to put this in here, state exceptions. Only 2 states do not require operators to post signs in order to receive liability protections, and that is Alaska and Montana. This is definitely something that stands out to me because when we talk about any type of immunity from liability statutes and not just agritourism, requiring signs with warning language seems like an integral part of the deal. If you don't post signs, you don't receive liability protection, except for Alaska and Montana. So, and like I'm thinking too of Pennsylvania's Equine Activity Act. With horses, anytime you go to a horse barn in Pennsylvania, you see warning signs. So I'm very used to seeing this signage, and so it's very strange to me that these states don't require it. Montana, though, we will talk about that more specifically, and I think when we get into that statute, you'll see why that is. Now, going back, I think I skipped a slide. I'm so sorry. Okay. Going back to our general architecture of this type of legislation, now we have the liability portion. In this section of the statute, most states either say an agritourism professional is not liable for damage or personal injury to a participant resulting from the inherent risks of an agritourism activity. Or the statute says something like participants assume the risk of agritourism activities. And then sometimes the statute actually says both things. So that's the language that you're going to see across the board for almost all of them. So we're probably not going to dig into this too much because it's usually pretty clear and straightforward across the board. This is what they're trying to do. This is what the immunity is. This is what the liability limitation is. Now, I kind of mentioned this a little bit earlier. We talked about this a lot, and it's such an important part of this whole discussion. So the big question is, what is an inherent risk? As an example, I ask on this slide, what would be an inherent risk at an animal petting zoo? I think most of us can assume that an animal might push you or knock you down. Even gentle, small animals like rabbits, if you've got a petting zoo with little rabbits that the kids can hold, but children are allowed and can sometimes move quickly or just startle the rabbits. And when rabbits become scared, they might tense up or move or jump, and they've got long claws, and so they could potentially scratch or seriously injure the person who's petting or holding that rabbit. So I would say that is a pretty good example of what would be an inherent risk with that particular activity. Now, with my second example, I ask, what would be an inherent risk at a U-pick farm? So, like an apple picking or pumpkin picking or blueberry picking operation. In that scenario, maybe if you're in an orchard, maybe, you're picking some apples and another apple falls down on a participant's head. Or maybe the participant falls off a ladder, even if it's just like a small step stool that they're just reaching a little bit higher and they fall and they get injured. I would think that those 2 scenarios are pretty likely with apple picking. I think most people going into, I'm going to pick apples off of a tree and it's going to involve climbing ladders and, reaching up to things above my head. That seems like an obvious or, an inherent risk. To me, that would meet the inherent risk. And it should be an obvious thing to anyone in the business. So maybe you as an agritourism operator is like, yeah, those are the kind of things that could happen to you. If you say that and it's very clear to you and clear to other people, that's going to be the inherent risk. If, you're apple picking and you get hit by a car, that is not going to be an inherent risk. I've never been apple picking and feared, like, I wonder if a car is going to come through this orchard and hit me. That's really not part of it. That's not part of the apple picking process. So that's what we mean when, there are things that are, obvious part of the agritourism activity and things that are not so much. It's when we're in that middle area where there's a gray area where it's kind of related or it's kind of not. That's where the question is, and that's where we get a lot of these lawsuits. So now that we've covered generally what most state statutes look like, I'm going to turn things over to the Pennsylvania's Agritourism Activity Protection Act for a deep dive on the specifics with that. For those of you who attended last year's presentation, this section is going to look pretty familiar, and at the risk of boring you, I hope that this is instead a helpful refresher. For anyone who is unfamiliar, we're going to take a look at the exact language of Pennsylvania's statute, which should give us a better idea of what one of these liability statutes look like in full detail. And Pennsylvania is a good example too, because it's not just a run-of-the-mill routine one. There's a lot of interesting exceptions that we'll talk about, and then I'll highlight again later and point out how it's different from other states. So just under 3 years ago, Pennsylvania passed its Agritourism Act. This newish sort of law it grants an agritourism activity provider liability protection from civil liability for injury or damages sustained by a third-party participant in an agritourism activity. But this does not apply to all agritourism activities. So Pennsylvania's act is different from other state liability statutes in a few significant ways. Unlike every other state, Pennsylvania specifically excludes liability protections for injuries that occur during weddings or concerts. So if you're a landowner who's familiar with agritourism in other states, just know that this state's liability immunity statute is going to be different. We're going to have to talk about these differences. In addition, they also the act does not apply to injuries sustained during overnight stays or as a result of food and beverage service. What I think is, a question for me, and we'll mention it later. I have this little icon on the side of 2 champagne glasses, and that's what I thought of when I saw food and beverage services. But it doesn't specify if it's, that doesn't specify alcohol, which is interesting because other states do mention alcohol specifically, and we'll talk about them with like wineries and even breweries at some point. So just an interesting thing to point out. So in order to receive liability protection, an agritourism operator has to meet these key elements of Pennsylvania statute. They have to qualify under the definition. The farm has to meet the definition of normal agricultural operations. They need to meet 2 different definitions. They need to include written agreements or tickets, and they must include signage. And we'll go over each of these. Like I said, this is the deep dive in Pennsylvania, so we'll talk about everything. Now, the first element that has to be met in order for this liability protection to apply is that the injury must occur while the visitor is participating in an activity that meets the definition of agritourism in the law. So, if I'm looking at this slide, it's, a farm-related tourism or farm-related entertainment activity that takes place on ag land and lets members of the general public, whether or not for a fee, to tour, explore, learn about, participate, or be entertained by ag production, harvesting, husbandry, or rural lifestyle that occurs on the farm. As you can see from that, this is a pretty broad definition, and unlike some states, it doesn't really highlight a specific activity to protect, or at least not an unusual activity or something that seems out of the ordinary. In other words, this language does pretty much cover most things agritourism, at least the types of agritourism that you would expect, other than, of course, the exceptions that were previously mentioned. Now, the second element, or element number 2, is that the agritourism activity must occur on land used for so-called normal agricultural operations. For the definition of normal agricultural operations, we have to go to Pennsylvania's right to farm law. So this is a quote from that. The definition generally states that a normal ag operation is an activity or procedure used by a farmer for production of poultry, livestock, and for the production of crops. This definition of a normal ag operation is also broad and should apply to most farms that grow produce or raise animals. That said, this definition also requires the farm to encompass at least 10 acres, or if less than 10 acres, must generate an annual income of $10,000 or more. I know that Ohio and Delaware also have a requirement for the property to be at least 10 acres, but I don't know off the top of my head if any other states mention this, the acreage requirement. Now, in this third element of Pennsylvania statute is that the visitor must sign an agreement to waive liability before they engage in the agritourism activity. I'm not going to read this whole thing. Very generally, this says, I understand that the agritourism provider is not liable for any injury to a participant resulting from an agritourism activity. I accept all risks. Please note at point number 1, there is no liability protection for the agritourism provider if they act in a grossly negligent manner, on purpose, or criminally. I don't go into this as much as maybe I should, but a lot of states have that exact language, and I kind of feel like it's pretty obvious. Like, of course, you're not going to get liability protection if it's gross negligence or you're acting on purpose. If you, as an operator, do something on purpose and like strike one of your attendees, yeah, of course you're not going to get the immunity from that. So I don't really dive into that or have many slides on that. I just think that should be obvious, but maybe in the future I'll talk about that a little bit more if people have questions about it. But yeah, if you purposefully hurt someone on your property, you cannot have this immunity statute apply. And then I just wanted to, yeah, I know that there's a lot of print on this slide and everything's kind of teeny tiny and hard to read. Now, I included all of that for a reason. I included that because I wanted to make it very clear that this written agreement, this waiver agreement, has to contain all of this information. So I decided to squeeze everything into one slide just to make sure that you know that this is the language you have to use. And whenever this written agreement is printed and used, it needs to be written in at least 10-point bold font, which is kind of small. 10-point font isn't huge. Logistically, the problem with this agreement is that it could be, difficult for some agritourism operators to work it out. Operators who want this liability protection are going to have to figure out some way to either filter their guests through a gate or a particular door or an entryway, so that people don't, enter their operation without signing these agreements. Now, if this is the first time you're hearing about this and you're thinking getting people to sign a waiver is going to be impossible I've been to a lot of agritourism operations. Like, how are we going to set that up? At least Pennsylvania does offer an alternative. So you have option A and option B. So Pennsylvania also allows agritourism operators to print that same agreement and warning language onto a ticket. 2 things to remember here. The ticket needs to include the language that we mentioned, and guests have to use that ticket to enter the activities. So they're handed a ticket that they have to use to get inside. So operators are still going to need to make sure that they're filtering their guests in some way to the entrance so that they can check to make sure that everyone has a ticket. The requirement for waivers or tickets is just another thing about Pennsylvania's law that's very unique. So in addition to Pennsylvania, only Georgia requires participants to sign a waiver. So several states actually mention waivers and mandate that certain language has to be used if waivers are used. For example, Montana mentions waivers and just says that waivers aren't prohibited. So they just have that language there, just letting you know you can use a waiver if you want to, which for what that's worth. Now, the fourth requirement for Pennsylvania statute refers to signage. The required warning signs have to be posted on the property at conspicuous locations and have to be 3 feet by 2 feet in size. I mentioned this earlier. Some states are very specific with how their signs have to look, and Pennsylvania is one of those states. It has to look exactly like this. They have to be placed, the signs have to be placed in a way that they're easy to observe or see by the participants wherever they are at the agritourism activity. The language warns the participants to read the agreement provided by the operator on the ticket, and the sign explains to the participants that the agritourism operator will not be liable for injuries should the participant be hurt while they are on the farm. With this section of the statute, Pennsylvania is finally, just like everybody else, it's very similar language. The warning language is pretty close to what everyone else uses. And one of the things I know is that language about placing the signs so that they're observable by the participants of the agritourism activity, that's going to actually come up later when we talk about signage as a whole. So the last thing on Pennsylvania, the law states that a parent or guardian must sign the acknowledgement agreement on behalf of a minor or care-dependent person. Uh, just generally, children do not have the legal capacity to sign liability waivers, and so a waiver signed by a child might be voidable. For this portion of this law, that's going to be up to the Pennsylvania courts to decide whether this law will have the intended effect when it comes to claims of injuries to minors. This is an unsettled legal issue, and we'll have to wait and see how the courts deal with this aspect of the law. Now, that said, a parent's signed waiver would waive the parent's claim for compensation relating to their child. So, as an adult, you can waive your own claim for liability for your dependent person, but you cannot waive their liability for themselves, generally. There is a Pennsylvania case on this. So, this was back in 1998, 1999, in Pennsylvania. So, in this case, Susan Shaner, she was a minor who was injured at a softball camp hosted by the university. The camp had required registration forms that had language releasing the university from liability. So Susan and her father both signed this form, but Susan was 14 years old at the time. The court held that in this case, the release signed by Susan's parent was not sufficient to waive Susan's claims. The court held that the parents do not have the authority to release the claims or potential claims of a minor child. As I mentioned it in the previous slide, contracts entered into by minors are voidable in most cases. In their brief, the court cited another case that says to void the contract, the minor must disaffirm it within a reasonable time after reaching majority. And in this case, the court did find that to be true. The court found that Susan brought the case within a reasonable amount of time after she turned 18. So again, this case was, a couple of decades ago. And then, the liability statute for Pennsylvania came out, just a couple years ago. So I don't know if this case is even going to be referenced, how this is all going to interact and apply in Pennsylvania, but I'm just putting the information out there, and we'll just have to see how the courts figure it out later on. Now, if you're interested in reading any of these Pennsylvania statutes, I have some links here on this. So if you have access to the PowerPoint slides from the website, you can click on these links and look at it. And I've also included a link to Pennsylvania Farm Bureau's resource page on agritourism. I especially recommend this to agritourism operators who are struggling to figure out signage, because the Farm Bureau has a link where you can just buy signs with the proper warning language. So that's kind of an easy way to do that. Some significant differences between state liability statutes. That's what we're talking about next. And so I feel like when we talk about differences, it's hard to have a focused path. We're kind of jumping around a little bit. So please forgive me. I promise there's a reason for the way that we're doing this. But it does feel a little bit, out of order sometimes. So one of the first differences that I'd like to highlight is the registration requirement. So while most states do not require agritourism operators to register, there are 7 exceptions. So Georgia, Kansas, Louisiana, Mississippi, Missouri, North Dakota, and Oklahoma. So with these states, operators have to register their activity in order to receive liability protection under their state statute. The language used in Louisiana's statute is actually a little unique in that it doesn't use the word registration in its statute. Louisiana requires operations to submit a plan of operation for approval, it's very similar. So I included them on this slide, but I'm also, I wonder if there are other states that have those requirements that are a little bit more nuanced and difficult to find. So this is one of those ones where I would love to know if you know of other states that have something that's not called a registration requirement, but is essentially requires agritourism operations to register. So if you know of anything like that, send it my way, because I'd love to build on this particular list, but these are the states that mention it specifically in their statutes. Now, on this slide, I've listed the 24 states that have provided agritourism protection, whether or not the provider requires a fee. And that whether or not language is key. You see that in most of these states. So it's very common language, but it's interesting for a couple reasons. The main reason is that there have been agritourism bills in the past that were proposed and then rejected, in part because they didn't apply or allow liability protection for operators who charged fees. In other words, with those bills, the agritourism operator would have needed to allow guests onto their property for free in order to acquire liability protection. That type of language isn't unusual in other rural recreation liability statutes, so it's not a surprise to see it in proposed bills. Practically speaking, though, free agritourism activities is not particularly helpful to farmers. So I think that just says to me that I think some of those states, when they created their language, they were probably borrowing from any rural recreation law or bill that they had and just copy pasting, and then, later realized, oh, if we don't let agritourism operators charge, they're not going to have this extra money for their farm, and it's not going to help them. Um, so next slide. Okay. So instead of having any states that, don't allow protection if they charge fees, we have the opposite. South Dakota and Georgia have this really interesting language. So they don't have the whether or not a fee is paid language. Instead, they mention that operators who charge admission are protected. So both states have language that says something like, a property owner who charges admission to an agritourism activity is not liable for injury. Interestingly, South Dakota actually originally had language included in the definition of agritourism activity that said liability protection applied whether or not the participant paid to participate in the activity. But then they removed that language in 2022. So they used to have the same language as everybody else, but then they took it away, and now they say they cover a property owner who charges a fee or charges admission, which is very interesting. And it's important to note while we're on this topic, with most states, operators will not receive liability protection when it comes to participants who are paid to participate. So if you have someone on your farm and you pay them to be on your farm and pay them to do the activities for whatever reason, that person, you are not immune from a lawsuit from that person. So a lot of states talk about that. Over the next few slides, I'm going to highlight some more unique activities that are mentioned by agritourism operations in their definitions. So I want to start with shooting ranges. There are 3 states that specifically mention shooting in their agritourism definition. You've got Colorado, they just list shooting, just shooting. And then you have Louisiana, that they specify skeet shooting, and then Montana, which specifies target shooting. One state actually specifically prohibits shooting, and that's North Carolina. And that's not mentioned in their statute, but was instead the result of a case, which I will have on the next slide here. All right, so for this case, Jeffries v. City of Harnett, this is from 2018. In this case, the landowner, Andrews, he owned 2 businesses. So one was a crop farm called Andrews Farms. Andrews leased property from his farm to himself for his other business called Drake Landing. That business, Drake Landing, was engaged in hunting and shooting activities. There's like 13 different ones. The neighbors, Jeffries and a few other people, they initiated this case requesting that the zoning authority make a determination as to whether the 13 different shooting activities offered at that operation constituted agritourism. And so the court determined that the outdoor shooting activities at Drake Landing, these were not agritourism. And in this case, that means that those shooting activities would be subject to zoning requirements for that particular area. So again, I mentioned zoning so important. So this isn't necessarily about an agritourism statute per se, but really just about local zoning. So according to the court in this case, the shooting activities were neither agriculture nor were they under a bona fide farm purpose. And a few states have that language with the bona fide farm purpose. So the court found that these activities were a non-farm purpose, even when conducted on a farm or conducted to prepare for hunting. The next thing I want to highlight is food and beverage coverage by the states. We have some states that definitely include meals. So New Hampshire mentions that meals are included. California, again, I shouldn't even mention them because it's not really agritourism, but they have that thing about agricultural homestays. But again, not liability protection, but I just included them because they mention it. And then Delaware, they mention bed and breakfast and picnicking. Louisiana mentions bed and breakfasts, and then Idaho, same thing. And again, I'm not trying to pick on Pennsylvania, but Pennsylvania does exclude food and beverages, so they are also on this slide as the one state that excludes it specifically. And I'm not saying other states won't allow these things. The point of these slides is to show you which states specifically mention something to include or exclude. So that's what's going on here. Like these states, I'm not saying that other states don't cover meals or do cover meals. I'm just saying which states have that language in their statute. So same thing with overnight stays. New Hampshire specifically allows overnight stays. California, again, we're talking about that same kind of non-statute statute. Hawaii allows overnight stays with some exceptions that are pretty unique to Hawaii. I'll have to check those out. Louisiana allows overnight stays. Minnesota allows overnight stays. Pennsylvania does not. Okay, and then moving to my favorite thing, wineries. This is a case from 2010 in New York, in Rivendell Winery v. Donovan. The plaintiff owners wanted to create a winery experience on their property. They had a couple acres of grapes and wanted to build a tasting room and invite people onto the property for wine tasting and direct sales. The court held in this case, the landowners did not meet the local definition of agriculture, and therefore the denial of their zoning application was affirmed. In this case, part of the problem for the landowners is that the zoning definition of agriculture required that they have not less than 7 acres used for production. The landowner here only had 1.5 acres prepared for grapes, but nothing planted. Plus, they had plans to lease another 10 acres, but they didn't even have a signed lease yet. So I wouldn't necessarily make this, indicative of how New York would rule on something like this. But again, this is the case from 2010. And things are a little different because in 2017, New York passed their agritourism liability statute. And in that definition, they specifically included wineries as part of their definition. So on this slide, you can see states that include wineries: Delaware, Iowa, Louisiana, Minnesota. They mention winemaking, not necessarily wineries. I'm not sure what the nuance is there. New Jersey, New York, Oregon, Virginia. And then we have states that also include breweries, Iowa and New Jersey. And I included the dates there for when those statutes were passed because it's 21 and 2023. So I'm wondering if that's a new trend because, they're very recent. So I'm wondering if more states are going to update, or maybe, as they come out with new language for their statutes, if they're going to start including breweries because of how popular those have become. So that's just an interesting thing I want to point out. And then, of course, just picking on Pennsylvania. Pennsylvania excludes food and beverage, although, as I mentioned before, didn't say anything about alcohol, but, food and beverage. And, okay. So in this 2021 Pennsylvania case, the neighboring landowners brought this case after finding out that their neighbor would be starting a winery. The land in question is zoned rural agriculture. The zoning board approved the winery application with conditions, and the neighbors appealed. The court spent some time explaining that wine production is agriculture, and activities described in the application are not unusual for wineries. Therefore, since the land is zoned agriculture, winery would be a permitted use. Okay, moving on to weddings. States that include weddings, specifically in their statutes. So Delaware, they mention barn parties or farm festivals. They don't say weddings, but I feel like that's very, very similar, probably would cover it. Same thing with Idaho. They mention farm festivals. Illinois mentions weddings or concerts. Kentucky just mentions weddings. And then, of course, Pennsylvania, no weddings. I didn't think I had enough, and then it turns out I had way too much. I'm just going to real quick end with this slide here on my new legislation because I just think it's so interesting. And anyone who's interested in learning a little bit more about what just happened recently with states, check out the rest of the slides. There's not too many more, but slides on new legislation and what's going on and what the changes are. Some of the more interesting ones that I thought, Colorado, they updated their statute to exclude marijuana as an agritourism activity, which I think is very funny. And then let's see, Virginia added horseback riding. That one wasn't quite as exciting. And let's see, the other most fun thing that I wanted to include is I really liked Montana's statute. because they included, theirs was really complicated. So I would check out Montana if you get a chance. And if you're just really interested in this kind of stuff and you love like learning about agritourism statutes for some reason, Montana is very interesting because they don't have, they have multiple definitions for it, and it's like layers upon layers. Let's see, what's a good summary? Good summary. Here's some practical tips for everyone. Review your insurance policies. If you haven't formed an entity, talk about it, think about it. It's probably something that you should do. Put up warning signs, even if they're not the exact right language, have some warning signs. Consider assumption of risk notices, consider doing waivers, do your weekly and daily safety checks for different aspects of your operation, and then review state legislation to see if it applies to you. I want to thank a couple of my research assistants here at the center for all of their work. Victoria and Kaden, I really appreciate everything you've done. All the resources that we have would not be available without the two of you. And while I'm at it, I guess I'll thank the National Ag Law Center because they have an excellent state agritourism statute compilation. You should definitely check it out. I've linked to their website on the resource sheet. And I'll throw out a thank you to Peggy Kirkhall, who wrote many of the articles that I referenced on the resource sheet. And that is it. That's all I got. So thank you so much, everyone, for joining us. Thank you for being here.
We hope everyone has a great weekend. Thanks, everyone.